We'll introduce all the speakers. Dear friends, good morning. It's great to see you here at such an early hour. Thank you for coming. I hope that our discussion will be interesting. What should we talk about in the morning? About education, of course. Because everybody starts learning something in the morning. And today we wanted to tell you about the idea that appeared some time ago from the Association of IP Chain, so the Association of Intellectual Property and Russian Academy of Intellectual Property decided to establish a new program. Skolkovo Foundation was also involved in this. So it was a new program about the intellectual property in the digital economy. Why is it new? We decided to take a very interesting approach. We decided to split the program into several modules to show how public relations influence the institution of intellectual property. How does it look from the technology point of view and from the community need, and how it can be monetized? So we launched a draft version of this curriculum for 120 academic hours. We wanted to test it first, and I think that this experiment was very successful. We had a lot of interesting speakers, so 120 hours only, but I had 23 different speakers talking as part of this program, and they were talking about data, about information security, about artificial intelligence, about smart contracts, apart from intellectual property, of course. So all the different subjects around intellectual property. And now I wanted to ask Sergei Matveyev to tell us more about the ideology of this curriculum, of this course, because he made an introduction to this course, and he gave a brief outline to all the students as to what this course was about. Let me talk about physiology and not ideology. I'm sure that people that came here are interested in innovations, so they are probably willing to know why it can be useful. So when we were developing this program, what we wanted to do is to make it clear what intellectual property and what IP rights are, because many people think about international convention, the civil code, counterfeit products, piracy, and a lot of different difficult issues, a lot of negative things, whereas intellectual property works in a different way. Well, intellectual property change the speed of the processes, but the processes might remain the same for years. Somebody create music or come up with innovative projects. For example, the recognition of images, or helicopter, or the system that gets the signals from the space. So lots of different ideas, whereas there's also a community that hasn't really created anything, but they just want to use it and even swallow it. It can be compared to wildlife, you know. So some people want to create things and some others want to take it over. And in order to support creators, intellectual property came into being. So it's up to the creators whether to let others use their property or not. So beginning with medieval ages and Renaissance, there have always been two subjects: the society that wants to use it for free, ideally, and the creators that have to make their living and they want to keep it to themselves. So it's all about natural rights, and we call them copyright. Some other rights are also there. When you didn't just think about some beautiful picture, but you perhaps designed some gearing mechanism, so you might develop a technical solution, but you can provide a right to prohibit others from using it. So maybe the creator can get a patent, and then it will be up to the creator whether to let use his or her creations or not. So, and this will be valid for 25 years or about so. So some rights appear at once, some appear later on after expert evaluation, and so this program had two angles: protecting the interests of the authors, of the creators, trying to limit the society as regards the use of everything that has been created, you know. And not all the rights depend on the relationships between the creators and society. Some rights are based on economic relations, and it's not that easy there. You probably know trademarks, domain names, so all these creates identification of business or the identity. And so, for example, not everybody can use Adidas brand or some startups that can be found here. So it protects the interests of society, and it prevents the society from using counterfeit or false objects. So there's the third vector in this program: how intellectual property works for economy and how economy can benefit from it. So the society, the economic interests, the interests of the creators or the authors. You know, we got used to this fact that we come up with some ideas, then we want to sign a license agreement, and this involves lawyers that one party hands over some rights to another party. So the number of the consumers are growing, and even though we have a lot of lawyers, it's not all the lawyers that can write the license agreements. And then blockchain appeared and smart contracts became common. So actually it's enough just to make some ticks in the information system, and that's it. Like I can give the right to these people to use this right, so it's there in the blockchain. And you can't remove anything from there. So IP chain sometimes use it for legal practices, so that's it. And music can be played and all the data is available, so the authors can get some royalties. And the fourth angle is how the technologies can simplify the protection of rights, how it works across borders, because Germany has their own rules and regulations. For example, 140 million people. What does it mean? That's not exactly a market. The market starts when the number of people reaches 500,000 at least. So this program is about the rights, what's the essence, how the artificial intelligence and what it can do and how it can help. So we speak about smart contracts, blockchain, artificial intelligence. All this hype has been created around it, but it's all very simple. You get right as soon as you create something, and blockchain is just an instrument that helps you make it easier. Smart contracts are there just to save your time, and you don't have to write it on paper. And then patent rights appears after expert evaluation, when experts analyze the situation and check, and they see that this is a real invention. It's not just something you added to the feature, to the existing feature. No, this is a new item. It can have industrial application, and yes, I joined two parts. I wouldn't get a patent for invention, but I can get a patent for industrial use. So artificial intelligence is a search engine that helps you identify whether you created something new or not. And that's what we talk about as part of the course, which runs for 120 hours. So it helps the artists satisfy their ambitions and explains how you can use your rights in the context of a digital economy. And IP management is a very important skill that everybody should know about and should be able to use. It's not dangerous. Thank you, Sergey. So we are trying to dispel myths here in the morning, and one of such myths is related to blockchain. Many people think that blockchain is only about cryptocurrency, but it's not true, because you can use it to record your international property. And now Ivan Zasursky is going to talk. He looks like a pirate. He misses the image of Funny Rogers. Yesterday we had a very interesting lecture, and I tried to ask him whether he respects copyright, and I mean the essence of it, not just those rights that related to what you own and your possessions, but many other things. So what do you think, Ivan? I think we share the common ground. We live on the same land, but let me start with a different myth. There are many myths that can be dispelled, and I would like to talk about a different thing, so that it would be interesting for many people. You know, there is the concept of discovery, and you know what it's all about. It's not something new. It is something when people came to understand what is there. For example, the planet of Mars or Jupiter. Yes, they have been there for ages, but it's only now that we begin to understand them. So then there are innovations, and Sergey gave a very good example of a bottle and a glass. Of course, he is not a real innovator. He won't be probably able to patent this. But actually, I'm the author of one patent, and it's about the system of differential correction of drones. But I actually don't have any patents. But anyway, I wanted to tell you that the discovery might have been there, but we reveal it and discover it for ourselves. And innovation is about synergy. When you combine different things from different time periods, or from different contexts, or from different fields, so the result might be completely new because you combined some things that can be quite familiar. Do you remember how Sony Walkman player appeared? You know, they made a small player, and they just decided not to use big speakers and use very tiny speakers. And then this process continued, and we got iPad, etc. So the main point is that we need exuberance of information in different forms and kinds. It can be protected and unprotected. The most important thing is for us to be able to find it and work with it. I am doing with some moral issues and saturation of information environment with knowledge, and it's very important for me to make it open as possible. I have these T-shirts with Wikipedia. You probably understand what I mean. The question is, how much do you need to generate innovations? For example, innovation is basically about the sparks that appear after the level of saturation is sufficient. So I think that what we need it's not that we have to protect everything. We can protect what's really needed, and that's it. I'm against legal nihilism. This is a fashionable concept, and I can explain you why. One of the key problems is that many works do not have the author or do not have rights owner or rights holder. Let's say there are some works of art that have been created, but you can't use them because you don't know the status. And I'm speaking about texts primarily, but it's also relevant about other works of art. So what's important now is just to register the property. What hasn't been registered is very difficult to use appropriately, and then they get stuck in some limbo space. You can't move, neither here nor there. So I think it's very important to reform the copyright law in order to distinguish between what should be protected and what should be protected. So the main idea is to make it closer to patent system, so that you could register intellectual property for some time, and then this period can be extended so that the right holder that created the IP item could be totally protected. But if you don't want to be protected, you shouldn't become some marginal character and an outcast. So now we are trying to protect those who don't need protection, and we can't give protection to those that really need it, because nobody really cares about anything. If we can download something, we think that it's an open access, so it's free and it's available, or we can get it via friends, so we also think that it's accessible and available, but it's not the right thing to do. So that's why we should have very transparent rules, and IP chain and this IPQuorum does very important things. Now there's the Association of Internet Editors take part in this project, I mean IP chain project, because it's very important to capture in blockchain something that is common for us, so that nobody requires that it is protected, so that it became the common good. We want to protect this from appropriation. Those items of intellectual property that have been published under open license. Do you know what open license is? It's 1.1 billion of works based on open license that are in circulation all over the world. And I think it's good. So there are these two poles: copyright, which is all about moral things, and the possessions. So they are completely different centers, like two different poles or magnets. So all this mess that we have on the table, we have to make this magnet work, and then the process of sorting out will become automatical, and it can have the useful forms. It can have the form of patent claim, or it can be prioritized appropriately. So this system could be extremely useful. And vice versa. We have to know exactly what we can use. The publishers in Russia publish a lot less books than in America, because we don't have many publications on the local market. And the same is true about film. People don't have a chance to get what they want in the Russian language, so the market remains very small, and it's also true about industrial property. The market is small, and many people think that it's useless. It doesn't make any sense. It's just easier to sell the company or to get people engaged into their work. It's just we are not used to legal culture, and that's why we have to talk about it, to disseminate this information and raise awareness. But the main myth that I wanted to dispel is this one. In order to have innovations, we shouldn't rely only on protected property. We have to have the abundance of things. It has to be accessible, and then we'll have many sparks, and all those sparks will be generated, and the puzzle will be complete.
Sergey, I'll give you a word now. Yesterday I wanted to ask regarding the discussion we had yesterday. Please raise your hands if you tried to find something, a movie or a book on legal resources, and failed to find it, and therefore had to use something not really legal. Absolute majority. So it illustrates what was mentioned by Ivan. We have a lack of the objects, information, different works, that the society needs. And the second point is, do you know how many books are really used from the Russian State Library out of the whole volume that is available? How many percent? How many percent have been requested at least once? What are your assumptions? Less than 10%. The rest is not demanded. Why? Probably because it can't be found, or can't be processed, or can't be, or nobody knows about the existence of such books because there are no any other books with the cross references. So in an ideal situation, it would be nice if the resource could give you the list according to your demands, but we don't have any resources like this, and this is one of the problems for the accessibility of knowledge. We started talking about the community interests, and I would like to come back to private interests. It seems to me that the program of this Department of Digital Economy included the speakers who explained that the right appears very naturally thanks to the technology. Here is an example. We have a glass. It's a very nice glass, and you invented a project how to manufacture the glasses with a special cover that always stay clean, and you developed a description of your project, and this description is a copyright item. You put it to blockchain, and you already have a proof that it was invented by you. Then you went to Skalkovo, you got a grant, you started manufacturing, and to enter the market, at a certain point you decided that this form of the glass is important for you. And based on the property item that is already in the blockchain and which is protected for 70 years since you die, you can forward this application to the Russian Patent Authority or forward it to Geneva and get protection on this form in 20 countries. It's a natural chain. When I need it, I requested new type of protection, and then I invented a cool name for my company, Hyper Ultra Glass, and then I requested protection for this name. And my company got the copyright for this form, for design, for our trademark, and then also invention of the type of glass that is not getting dirty. So this is the development chain for the intellectual property that must be natural, and you don't need to be afraid of it. I also believe that one of the main advantages given by the new technologies now is that we can quickly record the right and formalization of our thoughts and ideas. We don't need to collect tons of papers. We don't need to go to a patent attorney. Don't need to create a formal application, pay money. We can register some things much faster. And the laws of the international convention, which might be quite far from your world, the patent law contains the right of prior use. if you recorded your invention of this glass somewhere and you started inventing money, manufacturing, and you entered the money, and you found out that Bosch, for example, got a patent for the same glass, and you already have it in the box at the market, and Bosch goes to court with the claim that you break their patent, and you go to the court and use your right of prior use, and the court will make a decision that the patent holder must give you the right to use it within the scope of your record. And as Ivan mentioned, that we have more and more information. Yeah, Mendeleev's table is Mendeleev's. And what about CRISPR-Cas9 technology, which was invented in 2 laboratories in the same time? There were a lot of disputes about it, and the right of prior use protects you. The main thing is to have the proof when you invented. So, Ekaterina, her surname is Chukovskaya. If it rings you a bell, you probably understand that Ekaterina probably has something to do with the copyright. Also, she's one of the lead specialists in this sphere in Russia. My question is as follows. Ivan is speaking about the reform of copyright, and I'm very careful about reforms, about modification of basic principles and things that were established at the end of the 19th century and that we have been using for more than a century. What is your opinion? Do the technologies need alteration of the background of copyright protection and the Intellectual Property Institute, or it's just a help for us for some additional management, control, or additional services and options in this sphere? I sing sometimes. And my opinion about the technologies is that now we have the law that is going to come into force from the 1st of October, and it says that in the digital environment there is a new notion, and we still need to understand how it will be reflected on the copyright. I want to come back to the purpose of our discussion, presentation of our department. If my colleagues look into the future, my function in this department is to look into the past and record the present. One of the advantages of our department is that in addition to innovation prospects and emerging solutions, we are trying to give the basic knowledge, deep knowledge about the development of copyright and its current status in Russia and in the whole world. Because everything is changing very fast, but still it remains within a certain system. And it's a very interesting topic. My mission is caused by the two reasons. Umberto Eco said that only the one who knows the rules can criticize them, and most often we have critics from the people who don't understand how it works and what are the origins. And the second point is, which is also important, is that I did my best to listen to all the lectures, and a lot of speakers that I respect allowed the following phrases, like it will be boring, I'll tell you about some norms, and after that the funny thing will come, plans, perspectives, and so on. And the purpose of my course was that to explain that the civil code is not boring. And thanks God, we've found quite a lot of speakers who are passionate about what they're doing, who can tell you about the system of norms that is effective today and that we must comply with. And these are the people who can tell about it with fire, who can transfer their love to their subject, to the audience. And we were tempted to call it the module of law because it's mostly about the legal regulation, but it is devoted to almost to all the aspects of the copyright, like artists' rights, commercial artworks, trademarks, brands, and brands of the origin. And another advantage is also that we are explaining it in close connection with the historical development, and I mostly give my lectures for creative professions, not professional lawyers, but for the people who create the IP results and are the carriers of these rights. And I understood that any information is perceived better if a person feels that he or she is not alone. It's not a modern case when you first need to explain the terminology. And if you are speaking about a historical figure like the first case of inheritance of a copyright is from Hill. The same refers to Dumas and a lot of other historical examples that we give to our audience to explain how it works. I don't know any other educational establishments where intellectual property rights are taught in this way. Unfortunately, there are not so many institutions that have this course, even for the lawyers. And in my own experience, most of the trainings that must be devoted to IP rights are devoted to inheritance. And based on the results of our first course, maybe it will be a bit adjusted, but my impression is that the part of developments that I took part in was quite successful. And looking into the future is the function of our other modules, because we have a digital module, the module about community, economics, and so on. And I don't know why we called the department of the digital economy, because the three leaders of the department are lawyers, and I invite you all to our department. We do great things. Let's come back to the point mentioned by Ivan about the necessity to register, or what did you mean? Okay, let me explain. If we speak about the registration, the main idea is as follows. Can you write? Please tell me. Can you read? Can you write? Do you know that each of you is a right holder? According to the Berne Convention, everything that you've written, okay, not everything, Ekaterina will correct me, if you didn't invest your intellectual efforts into your writing, yeah, or a smile won't be part of this, right? Yeah, she is right. She is right. Everything written by you, everything ever done by you is protected in the same way as a Hollywood blockbuster under the law. From the point of view of the legislation, there is no difference, and this is meaningless in my opinion. If you created something to share your mood, your impressions, to give people the opportunity to get an important piece of information, and you don't want to close access to it, you want to make it accessible. Based on my proposal, you don't need to do anything. It won't be protected for anything but commercial purposes. It won't be used in commercial purposes because it's a criminal offense. But the rest of uses are possible. Copying, indexing, references, and non-commercial personal use is free. But if you really need this property, you register it and get a patent. You just register it in IP chain or in RIS, now sfere. You register the rights that you want to have, and I think it shouldn't last for the whole validity period of the copyright. It must be for 15 years or so. Let it cost 1 ruble or 1,000 rubles, but if in 15 years you didn't remember about it, let it be a free thing. If you didn't make any use of it, you don't need it. Why shall we protect it? Why shall we spend taxpayers' money for it? It's useless. But if in 15 years you understood that you really need this property and you can adjust the automatic payments for 1 ruble or 1,000 rubles in any automatic application, there must be an amount of money that you pay to make you think about it. Let it be 1,000 rubles. Is it much for you to pay for 15 years? If it's too much, don't pay. Let people use it. Maybe it will be useful for somebody. And if you are ready to pay, then you can prolong it till the very end, even automatically, if there are money on your account. It's not an issue. But the borderline is important. It should be more clear, because there are some things that nobody wants to protect, and they must not be protected. We don't have to spend our limited resources for the protection of what nobody needs. And if somebody needs a certain thing, nobody should have a possibility to steal it or use it unlawfully. I think it's the legal culture. And you might think about it as a radical idea, but it's not. In such countries as the USA, China, you can't go to court regarding copyright without any registration, even now. Otherwise, the first sitting must be not about violation of the copyright, but establishing the author. It doesn't use the word of registration, but there is such culture in the USA, really. If you wrote something and you think that your rights can be violated, you go to the Library of the Congress and you apply for the registration. But unless you do so, the American court, if Serежа took my book and published half of the book, but it was not registered by me, I won't be able to come to him in the US. First, I must register my right. And the American Copyright Office is interesting. It allows different people register the right for the same thing. They don't check. There was a piece of news that somebody registered the right for Bitcoin. Are you Satoshi? And he said, yeah, I'm Satoshi. They say, okay, we believe you, but please take into account if another Satoshi comes, we will register him as well. No problem. And now everybody is thinking about whether it will go to court or not. He can't do anything with this copyright, and the Copyright Office is not the place where they will go deep into details. When there is a registration, there is a certain legal mode, and somebody who disagrees with the right of a certain person can go to court, or at least there are procedures and something to speak about. And the same is in China. If you want to stop counterfeit, then you go to court, you say that it's my T-shirt and they've done it for me and they didn't pay anything to me.
But how can I understand that it's really yours? For example, you have some questions to the Chinese people, but have you really registered your right? So that's why you can't really expect much. They will sell their stock of T-shirts and you won't be able to find anybody. So you have to understand that, yes, Bern Convention, Geneva Convention, WIPO also exist. But it doesn't really matter because the rights are protected in a different way. Nobody is going to claim the moral right. But if we speak about real protection via judicial system, it can be used only after registration. And I think it's the right thing. So briefly, what Ivan suggests is understand the presumption that everything is protected. So the right holder, the right owner has to articulate their will that they let anybody use this via blockchain, whereas Ivan suggests to do something opposite. So only if you want to protect your item, you can articulate your will. And in this case, it would be more relevant. Yeah, protected or not protected. But let's say this is my land, and this is my field. I'm not going to work here. So if you can see that I didn't plow it, anybody can come and use it, like planting something, seeding, because I'm not using it. It's empty, so nothing happens on this plot of land. Why can't you use it? You can. It's just a matter of whether we decide to do it or not. But you know, in agriculture, actually they have this provision in agricultural regulation. If you don't use the land for a long time, it will be given back. You can't keep it. Well, it's good that this surveillance authorities don't go and check it, but it's the existing regulation. For example, if you lease, if you decide to rent some agricultural land, and you don't do anything there, you will have to leave, because they will take away the land from you. So, if you create something and you don't need it, you haven't done anything to protect it, and I assure you that it will cost peanuts. So, Sergey already explained and described different services that can be used. So, it will be done instantaneously and very easy. It means everybody can use it, because if you haven't done it, well, if you haven't protected it, then others can use it. So if you register it, then you want to protect it. That's the approach that we should use. I don't mind. But I want you to understand that it doesn't exist yet, because you might have the impression that it has already happened. And my colleagues can look into the future and see already these opportunities and services there. But the existing legislation doesn't prevent the creators from articulating their will. For example, if we take a look at the copyright, you can't actually refuse from copyright, because copyright might involve some responsibility. Maybe they want to throw to topple the government. So, as to rejecting your possessions, and sometimes it's not even indicated in legislation. We have a free license when the author lets their works to be used by a broad community. So what Ivan suggests is the system that protects the users. So let's say I'm the author and I let anybody use my book, for example, create comics on the basis of it, or use it in film. So, but I haven't articulated this. It means I don't use any techniques of protection. But what if I change my mind, because I haven't really said anything? I just ignored this. So Ivan suggests that everybody takes a more proactive position. If I want to protect it, I have to say about it. And then the users have the guarantee that I won't change my mind, because, you know, I didn't really give any attention to this, but now I think differently. And this is what we talk about as part of our course. So there are different ways and different options. Just recently, a couple of weeks ago, the final version of European directive has been published, and I think it has very strange and unusual mechanisms. And if we are to discuss the trends and what kind of relief we have. Now I feel as if we are tightening the screws. It's like a slide back, as if we get back to the old system that we already forgot. So it's important to see how we are to interact. We already discussed some issues, and I'm sure that we will face some problems. It's good to make plans, but it's very important to relate them to reality. So it's great that we had such a heated discussion while discussing this course, this new program. So it's great that we could express our points of view. It's good because we're all sober, and it might have been different if we had this discussion in the evening. I'm afraid we have to close because we're running out of time, but I can see a colleague having a question. Well, hopefully we can have a couple of more minutes, and then we will close it. What about pioneers' inventions? Officials often say that we don't have any good projects. The inventors are not any good, but the officials are great. Judging by the number of licenses given abroad, there are so many, whereas here in Russia, we have a lot of pioneer inventions that could generate a lot of money, a lot of income comparable to gas income. So if we compare it even with Skolkovo, the most of inventions have small scale, and that's the reason why we are lagging behind. Well, the Soviet Union collapsed many years ago, and the intellectual property, beginning with 2008, intellectual property became private property. So if you have the status of invention, you can do whatever you want to do. You can give it to any one. You can give it to users here in Russia or somewhere else. Like Ivan said, all the ideas have to find their uses. So please find those that will find your ideas useful. It's quite stupid to expect the government to be proactive here. It's up to you, and the intellectual property rights just help us to spread our ideas. When you get a patent, when your ideas are recognized as innovative, of course, it can bring you a lot of money. I actually also have a question. If you go to China with our invention, they will use the invention and nobody will be able to prove anything. Well, you have to take preventive measures. That's very important. But they are all pirates. We have to make sure that all the works registered in Russia are protected, at least in two countries. At least in two countries, in China and in India. And in this case, we'll have 40% of global market. If IP chain helps to create a situation when we have an automatic registration on two markets at least, India and China, what about America? America will never work with an alien system of registration. China has 1 billion users, and China and India will make 3 billion people, and there are 7 billion people all in all on the planet. Yeah, they can find gold there. So, guys, we have to close our discussion. Please come and join our program. You will find it great fun. And this chair is located right in the center.
Спасибо огромное, дамы и господа. Давайте поаплодируем первой на сегодня панельной дискуссии.